And now it is my great pleasure and honor to welcome Mr. Gencarelli, Head of Unit for International Data Flows and Data Protection from the European Commission. Mr. Gencarelli, thank you for joining us today.
Ladies and gentlemen, good morning. It's a true honor and a real pleasure to be here this morning, a few days after the beginning of the first Croatian presidency of the Union and a few days after the visit of President von der Leyen and the rest of the European Commission College to Zagreb. I really want to thank the Personal Data Protection Agency for organizing today's event and for inviting the European Commission. In its program, the Croatian presidency of the Union has brought the topics on which it will focus in the next 6 months on the 4 priorities, on the 4 key elements. A Europe that develops, a Europe that connects, a Europe that protects, and an influential Europe in the world. Actually, privacy, and in particular the issues we are discussing today, concerns each of these 4 priorities. I have been asked to focus on the last one, the international dimension of data protection. But as this panel is about GDPR as a business opportunity, I will also say a few words on what the GDPR means back home in the EU for our competitiveness. This will also give me the opportunity to share some lessons learned from the first year and a half of application of the GDPR. These are, by the way, and clearly complementary aspects. If we want to effectively address challenges and opportunities that are increasingly global in nature and scope, this can be achieved only through close cooperation with our international partners, and on the basis of a common vision that acknowledges that in today's world, more than ever before, privacy needs to be effectively protected as part of a human-centric approach to these opportunities and challenges. This is a question of fundamental rights, as recognized by the EU and the national constitutional framework, but it is also an increasingly a democratic imperative at a time where the very integrity of our electoral processes can be threatened by misuse of data, as well as an economic necessity. Without consumer trust in the way their data is handled, there can be no sustainable growth of our increasingly data-driven economy, and this has been said also by many of the previous speakers. This is why in the EU, and increasingly in a growing number of countries around the world, data protection is a central component of digital policies. In the EU, from the digital single market to the new strategy on artificial intelligence that the Commission will adopt in the coming weeks, the Democracy Action Plan, etc. Data protection has become part of the regulatory flow for a wide range of policies, from health to research, from transport to energy, from financial services to law enforcement. And we are certainly seeing the positive effects of that choice. While, as it is normal for any major piece of legislation, the GDPR has, of course, required adaptation, has raised many questions. But none of the doom and gloom scenarios we were hearing before the new law entered into force has materialized. What we hear from businesses is that the application of the GDPR has been, first of all, an opportunity to put their data house in order by taking a closer look at what data they are collecting, what they use that data for, how they keep it, do they share it, and not the least, do they really need to collect and process all this data? Answering this question has often allowed businesses to reduce exposure to unnecessary risks. As explained, for instance, in a report issued by the IT big company Cisco, complying with GDPR has led companies to being better prepared to avoid security breaches and or more responsive in case of incident that allow them to then mitigate the consequences of such incidents. This is far from being insignificant nowadays if we consider the financial losses and all the reputation damages that such breach can cause. Think, for instance, of last year downgrade by Moody's of Equifax following a, of course, very famous security incident. Answering those questions has also often allowed businesses to get a better idea of what data they hold and how to better exploit it by developing a more trustworthy relationship with their customer with their customers and commercial partners. What we also see is that data protection is increasingly a selling point, as more and more users value the privacy and security of their data. For instance, we are observing on the marketplace the offer of innovative products and services with novel privacy or security solutions. Many companies say now that privacy is increasingly becoming a competitive differentiator in their markets. In that respect, the same Cisco study report I was referring to showed that a growing number of consumers care about privacy, which means that they see privacy as an important factor influencing their buying decision, their online behavior. Which means, for a significant number of them, that they have already taken action to protect their privacy, for example, by switching companies or providers because of their data policy or data sharing practices. Interestingly, this privacy active segment of the population is not only sizable, but it also represents for businesses probably the most attractive part of the population. We are talking here of people that are, to a very large extent, under the age of 45, that are the consumer, the segment of the population that does more of their shopping online compared to other segments of the population. So that's very far from the myths that we were hearing even a few years ago. Sometimes we still hear that people don't care about privacy. I'm referring to those examples, to those benefits, because they go well beyond just meeting legal or regulatory requirements. 1 year and a half is, of course, a too short period to try to draw any definitive conclusion on the impact of the GDPR. But those are certainly interesting trends that we will continue to monitor, including in the context of the May 2020 evaluation that the Commission will conduct on the GDPR. The GDPR requires us, 2 years after its entry into force, to evaluate the application of the GDPR, in particular as regards certain aspects. That exercise has already started with consultation of member states. There was an interesting paper issued by the Finnish presidency of the EU, the one which preceded the Croatian one on this. Data protection authorities, the board is working on its input. Stakeholders are being consulted. This will not be about reviewing or amending the GDPR, but rather about understanding better how it functions on the ground, where to focus in terms of further action. For instance, making full use of the entire GDPR toolbox to help companies, to support companies in complying with its obligation. There are a number of tools which are yet not fully used or underused. Standard contractual clauses, certification, codes of conduct that can be particularly useful and cost-effective for companies, in particular small and medium companies that cannot rely on sophisticated and costly legal advice. So those tools can indeed help companies complying with their obligation and bring more legal certainty. This will also require that our data protection authorities take actions as particularly on certain of these tools, they are the main players. Data protection authorities, that's indeed a central piece, element of our approach to privacy in the EU, of the EU privacy regulatory and governance landscape. I believe that it's now clear to everybody that since May 2018, European data protection authorities have not transformed themselves into finding machines. They have instead rolled up their sleeves and constructively engaged with stakeholders with the understanding that compliance is a dynamic process. This has resulted notably in the issuance of more than 20 detailed guidelines in the last 2 years, fleshing out the novel aspect of the EU data protection regime, 20 or more detailed guidelines adopted by the European Data Protection Board, each time following public consultation. More will come in the next month to address the application of data protection rules in rapidly evolving areas such as blockchain or connected autonomous cars. This shows that in a fast evolving field as data processing, and as the law, in this case the GDPR, has necessarily to stay at a certain level of generality, This type of guidance, this type of role of data protection authorities is absolutely essential to provide consistent interpretation throughout the EU and adapt the rules, adapt the application of the rules to developments, technological developments, commercial developments that for very clear reason couldn't, in certain cases, could not even been foreseen, haven't been foreseen when those rules were negotiated and adopted. This dynamic process based on close dialogue with stakeholders has also resulted in the development of innovative tools in the way data protection authorities operate, and in particular in their relationship with companies, with businesses. Toolkits for SMEs and micro businesses, incentivizing privacy-friendly innovation through a regulatory sandbox, through which companies launching innovative products and services can approach their DPA to work with it on limiting the risk, the impact on privacy of their data-intensive new product or services. The role of data protection authorities will only become even more significant. Within the EU, we have heard from my Irish colleague that some very important decision on cross-border cases concerning some of the biggest tech players are coming, but also within the EU, I think there is an expectation that the European Data Protection Board and data protection authorities will be a key driver to a consistent application of the rules throughout the EU, but also at international level. I think there is a clear need, we believe that there's a clear need for more international cooperation between enforcers at a time when in Europe, in Asia, in the Americas, regulators, enforcers are increasingly dealing with similar compliance issues or similar compliance breaches, incidents that simultaneously affect the citizens of multiple jurisdictions. And actually, there's very little cooperation, effective cooperation, still in the area of privacy, contrary to other regulatory areas. Such cooperation through the development of common interpretative tools or standards can also contribute to ensure a clear legal environment for business operating in several jurisdictions. For those reasons, the European Commission is committed to working on facilitating cooperation and mutual assistance between EU and foreign regulators, including by making use of some of the new powers we received under the GDPR. We are actually already starting by a very concrete step, by setting up what we call a data protection academy to favor exchange of knowledge, views, best practices, and experience between privacy regulators, EU and foreign ones, and to develop in this way cooperation on the ground, and we want to open that academy, that process, to any interested international partner. This brings me to the last but main point that I wanted to address: global convergence in privacy standards. One thing is clear today, and it's happening. The key elements, the key components of a modern privacy framework, a comprehensive legislation rather than sectoral rules, a core set of enforceable rights, a robust independent regulators, these elements, this feature, are increasingly shared globally, from Chile to South Korea, from Brazil to Japan, from Kenya to India, from Tunisia to Indonesia, just to give a few examples. That's also very different from what we were hearing a few years before. When I personally started to work on privacy, was some time ago, but not so long time ago, I was hearing privacy is a European obsession because of your history, because it's always I always have doubts and concern when I hear this kind of cultural relativist comments, but that's what we were hearing. And now we are seeing that because countries around the world are facing the same challenges, they actually equip themselves with a similar rule. This increasing convergence is already reflected, for instance, for instance, in the increasing universal membership of the Council of Europe Convention 108, which used to be a European instrument, but which has now membership from Africa, from Latin America, etc. And this, and in fact, in a world that is too often characterized by fragmentation, different, if not different approach, this trend towards global convergence is a positive development that brings new opportunity to increase the protection of Europeans when their data move around, move abroad, is transferred in a third country, but also to facilitate data flows and thus trade, to facilitate data exchanges and therefore cooperation between public authorities, including in the area of law enforcement. It was very interesting to hear this morning that the Deputy Prime Minister mentioned actually the Law Enforcement Directive as an enabler, as a facilitator of law enforcement cooperation. We very much believe in this, but it's even better when a leader of one of our member states says it and has seen it on the ground. This is a win-win situation. This convergence is a win-win situation for consumers and business as well as public authorities. It is also, it was very interesting to read, I don't know if you've seen, but Chancellor Merkel had a very long interview with the Financial Times that was published this morning, and she said that the GDPR is important for the EU because it shows that Europe can become a rule maker rather than a rule taker when it comes to the digital economy. The recent concluded the recently entered into force EU-Japan mutual adequacy arrangement, establishing the world's largest area of free and safe data flows, illustrates that point. The result of that arrangement have been immediate and very beneficial for the two economies. Since February of last year, data can flow freely between the EU and Japan between Japan and the EU, without any need for authorization, sophisticated contract certification, or other costly mechanism. This is particularly advantageous, of course, for business, for companies, in particular the small and medium ones that don't need to even think about using any of the complicated transfer mechanism. By allowing the free flow of data, that arrangement also amplified the benefits of the recently concluded free trade agreement between Japan and the EU. This shows, and that's also very different from what we were hearing a few years ago, this shows how trade instruments and data protection tools can complement each other. If you want, this is an element of what we consider as free and fair trade. We see a lot of such opportunities in many regions of the world, where the convergent trend I was referring to earlier is particularly strong. For instance, we are at an advanced stage of our adequacy talks with South Korea. We are also working closely with a number of Latin American countries. We will certainly intensify our engagement with international partners to further promote and build on that convergence trend. Closer to home, and it's difficult to avoid the topic, there is, of course, Brexit. And adequacy, and in general, data flows should play an important part in that context too. Of course, if the conditions for adequacy are fulfilled by our UK friends. Why an important role? An important role, of course, to facilitate the future trade, but also security partnership. But an important role also as a key level playing field safeguard. This, once again, it's about fair conditions, it's about competing, having a level playing field with our companies, and the companies of a future third country can compete on equal terms. While, of course, we will continue to promote convergence of data protection standards at international level, at the same time, and that will be really my last point, we are at the Commission equally determined to tackle digital protectionist measures that have nothing to do with genuine privacy laws, such as, for instance, forced data localization or storage requirements. This is why we are now systematically tabling in our bilateral and multilateral negotiation novel language prohibiting such measures. This is very important to enable our companies to enter and expand their presence in certain markets where such data protectionist measures exist. As you can see, we will probably be very busy working together in the coming months and years within the EU and with our international partners, closer to home or more distant partners. And as I was saying in introducing my remarks, that's how it should be if we want to address challenges and opportunities that are increasingly global in nature and scope. Thank you very much for your attention.